Good morning. Whoa, that's loud. Hello. Good morning. Nice. It sort of doesn't really work. No. I don't whistle. Only after 4 tries. Welcome to the forum. The person who's the Jayest of the J on the Myers-Briggs on our team just said, "Do your job. Do your thing that you have to do. Start this thing." Good morning. Most of you were at 9, but not all of you. I'm not taking any names. So some of you have heard this announcement, but John Roars and his wife are enjoying a very well-deserved vacation at an undisclosed location. So you're stuck with the rest of us today. He'll be back next Sunday, and next Sunday in this time will be the final forum of the program year, where he and I and Penn Rogers, I just saw you, there you are, and some other people from the executive committee of the vestry will just give some sort of one of our nothing controversial, just normal updates, getting into that practice, and we'll have a couple reflections about where we are and looking forward and all that stuff. So just please try to make that or watch it online, and then 2 weeks from that will be the last forum of the program year. We'll come back in September. And then on the 21st, one of the assisting bishops in Virginia will be here. So we'll have a big reception after the 11:15. We won't have a forum. And all those confirmations will happen at 11:15. So thank you. And I'm going to turn it over to Bill.
Thank you very much. Blair Nelson, is he? Here he comes.
Good morning. Hi, I'm Blair Nelson. I am chairman of our stewardship committee. Some of you may not know what that is. It's a relatively new committee. We're about a year and a half old now. Working to provide educational opportunities throughout the year to our church members, and also to make sure that stewardship is something that we never forget about. It's not just of giving of our money, it's our time and our talent also back to the church. One thing that one thing we're working on right now is reviving the Legacy Society. And if you don't know what the Legacy Society is, it's our way of recognizing those individuals who have agreed to mention the church in their estate planning. And it's something that many of you in here may already have taken advantage of. If you do not know about the Legacy Society, we invite you to stop by the table where Ann and Fern are sitting there to answer any questions, and we have brochures and information on the Legacy Society. So with that, thank you very much for being here, and I'll turn it back over to Bill.
Thank you very much, Blair, and thank you, Will, as well. I'm delighted and honored to introduce our speaker today, Matthew Farley, local attorney, local firm, graduate of St. Christopher's, Sewanee, and the University of Richmond Law School. Many of you know Matthew Farley, and I join that line. He has been a great service and support to me. And without further ado, since time is compressed, Matthew, welcome.
Thank you. Can you hear me? What should I be paying attention to for time? 11 o'clock. Okay. Thank you all very much. Would you believe me if I said this talk and your stewardship campaign have nothing to do with each other? But I grew up at St. Bridget's, so I'm sorry, I had nothing to do with the bells. I understand their source of frustration. So anyway, I'm really glad to be here. A lot of familiar faces, a lot of faces that have not seen me dressed up. I noticed a bunch of people from the fitness center, and they've only seen me in shorts and t-shirt. So anyway, I'm really glad to be here, and thank you, Bill, for asking me. So I grew up here in Richmond. As Bill said, went to St. Christopher's in Sewanee and U of R Law School. I've been married for many years.
Can you hold the mic right at your mouth?
Yes.
There. Oh.
I can't promise it'll stay there. 3 kids, all of them in college, one at Sewanee, one at UVA, and one graduated from Virginia Tech and is now in graduate school. So I've been in Richmond my whole life. And my firm, I've been practicing law since 1998. I'm just seeing people. This is hard for me. Like, I just saw Coates. Coates was one of the, I started at Maids and Valentine in 1998 doing litigation and white-collar criminal defense work. Took me about 3 years to burn out on that. And then I went to see Jane Schwarzschild and said, do you have a spot in the Trust and Estates group? And so that was one of the best decisions I made. So talking about estate planning, one of the things when I did talk to Jane that first time, I thought it was a really narrow area, right? You just write wills for people. And it turns out in the 20 plus years I've been doing this, I am constantly amazed at how broad a topic it is. It covers so many things. We deal with disposing of assets, probably what most people would think about. My expression for that, which I have not patented yet, but is who gets what, when, and under what conditions. That describes a lot of what we do, but taxes play a big role in what we do. Planning for incapacity, powers of attorney, advanced medical directives, end of life conversations surround those documents as well. Business succession planning, planning for how to hold assets for spouses and children, whether those gifts are outright or in trust, special needs trusts for children who may have, people who may have disabilities. It really runs the gamut. One of the topics that's become more prevalent in my practice is planning for loved ones who may be suffering from addiction. Second marriages, spendthrift children, you name it. We see all of that. And so this little area of, I just want to write wills for people turns out to be a whole lot broader. I should say from the outset, I don't know how this normally goes. Someone told me right before I came up that the forum usually covers more spiritual matters. And I'm pretty good at making connections, but I don't think I can make this spiritual. So we're going to aim for practical today. And I will invite anybody who has questions as I'm going to please ask them. I often say I should get paid by the word because I can talk a lot. But I think this is better if you have a question, just raise your hand. There's my old neighbor. Really, this is amazing. All right, so I thought I'd talk a little bit, it doesn't apply to all that many people anymore, but I thought I would talk a little bit about taxes first before you go to sleep. So we deal a lot with the estate, gift, and generation skipping tax. And when I started practicing law in 1998, the estate tax exemption was $625,000 per person. It is now $12.9 million. And when I started practice, the estate tax exemption was a use it or lose it thing. So if I had $625,000 and my wife had zero and she died, her exemption went away. We didn't get to use it. We now have something called portability where in that same scenario, if my wife dies, I get her exemption. And so for a married couple, the estate exemption is over $25 million. And so unless you're over 25 million, you don't have to worry about estate taxes today. If you're over 25 million, then that's something we plan for. Now, if anyone follows these issues in the news, you know that Congress, nothing ever really stays the same. And in 2026, the estate tax exemption gets cut in half. And that is assuming nothing happens before that. So then in 2026, a married couple have roughly 12, 13 million of exemption. So that's something we're always looking at, just to make sure if a client has a taxable estate that we're aware of it and planning for it to either avoid or postpone tax as much as we can. A lot of people, you know, when back in, I guess it was 2010, the estate tax was repealed. And then it came back. A great article in the Wall Street Journal about all the billionaires who died in 2010, including George Steinbrenner, when there was no estate tax. And lo and behold, about 3 months later, Congress said, well, we're going to bring it back retroactively. Because you can just do the math, you know, a couple billion times 40%, and that's what they were losing. But a lot of folks would say, you know, with these higher exemptions or no estate tax, Matthew, you'll be out of a job. You won't have anything to do. And the truth is that even with clients who have substantial wealth, most of them are more interested in the non-tax aspects of their estate plan. The who gets what, when, and under what conditions part of it. And so I thought it would be useful just to talk about some basic documents that really I think everyone should have. As my friend JB said this morning to me, the state has already written a will for you. And so you might want to write your own. Because if you die without a will, there's a statute in Virginia that tells us what to do with your stuff. And the other thing that was interesting to me, this morning in the parking lot, as I was preparing some notes, I Googled who died without a will. Famous people: Prince, Jimi Hendrix, Picasso, Michael Jackson, but then they found a will. And my favorite is the Chief Justice of the Supreme Court, Warren Burger, he died in 1995. And I thought he died without a will. He actually made his own. It was 179 words on one piece of paper. And according to the article on the internet, it was full of typos. And took a whole lot of legal wrangling to interpret and understand. So I don't want to assume everyone in here has done great estate planning. I hope you have. But some of the basic documents that we do for just about anybody: power of attorney and advanced medical directives. Those are documents that are in effect while you're living, usually limited to when you're incapacitated in practice, but they're not restricted to that, where you've got an agent to manage your financial affairs or to make healthcare decisions for you. The medical directive also states what your intentions are if you are terminally ill, so that we don't have to guess. It's been a while, but most of you all remember Terri Schiavo, the lady down in Florida. There was a huge fight over her. She was in a comatose state, and there was a fight between her parents and her husband about what to do. And none of us would have heard of her if she had signed an advanced medical directive, because it would have told us what her intentions were. So those are very important documents. And my PSA for the day on that one is, if you don't have a power of attorney and a medical directive and you become incapacitated, we are going to be in court. And we're going to be asking the court to declare you incapacitated and to have a guardian and a conservator appointed for you. And I used to do a lot of those cases. I haven't in a while. I will tell you, I've never been involved in a divorce personally or professionally, but a contested guardianship case is about as ugly a legal proceeding as there is. So do yourself and your loved ones a favor and make sure you have a power of attorney and a medical directive. The other thing that comes up a lot that I thought I'd just mention is the medical directive is different than a DNR, a do not resuscitate order. We don't prepare those. That has to be done with your doctor. And so I don't know, that question seems to come up a lot with people who mom or dad is in the hospital and the adult children are calling us and saying, well, mom, they have a medical directive, where's the DNR? And it's just a different document that's done in a different way. All right. I'd like to say that was the pick-me-up part of my talk. But it gets worse. There's really no way. I mean, when I meet with clients and I'm talking about who dies, I make up like the piano fell out of the building and hit you on the head, or the bus hit you and then backed up and took out your husband. There's no easy way or fun or uplifting way to talk about this stuff. The other two basic documents we do a lot of course, are wills and revocable trusts. And now we're disposing of assets at your death. Issues that, and there's a whole lot that goes into those. I'm going to touch on a few of those issues different or separately. But with the will, you're appointing, you're disposing of assets. You're appointing an executor. You might be appointing a trustee. And for those with minor children, you're appointing guardians for your minor children if both parents are deceased. Probably nothing, it's somewhat overlooked, I guess, in that we seem to do a lot of talking about how to dispose of assets, but I don't know that there's much more important than selecting a guardian for your minor children. So when we talk about revocable trusts, I suspect most of you have heard about revocable trusts. The reason we do those primarily is to avoid probate when you die. Also, a benefit of a revocable trust is that the terms of that document are private. So, and whereas a will is a public document that gets recorded in the courthouse. My favorite from a long time ago, we were at Mays and Valentine and we were being interviewed for work related to Jack Kent Cooke's estate, former owner of the Redskins. And someone said, you know, you can just call the court in Fairfax or wherever he was and get his will. And someone did that, and he had every provision in there. I don't know if you all remember Jack Kent Cooke, but he had lots of wives, and he had lots of non-wives. And, you know, he was, I'm going to give $50,000 to Betsy. Well, who the hell is Betsy? No one ever heard of her. And so that's all public for anybody to see, and whereas the terms of a revocable trust are private. And I don't know, most, you know, when I'm trying to explain the reason why you would want a revocable trust and what probate is, it's this sort of amorphous thing, unless you've been through it. And if you've been through it with a parent or a spouse or another loved one, the way I think of probate is it's really the court supervising your estate. And so you go to your executor goes to the courthouse and they probate your will and they qualify. And anytime you do anything with a court, there's a filing fee. And you're filing an inventory of all your assets that's now a public record. And there's an official in Virginia in each jurisdiction called a commissioner of accounts. And they audit your estate and your executor. Fees, more forms. In Virginia, probate's not horrible, but also think about if you have assets in different states. So Client has assets in Virginia, Florida, and Montana. Well, now their children have to go to 3 states to go through probate. So you can avoid all of that by creating a revocable trust. And then, it's funny, most of my clients, we meet, we talk about what they want, I draft their documents, they review them, there might be questions, changes, they come back, they sign it, they're so relieved. I say you're 50% done. Because if you create a revocable trust, you haven't done really much of anything. Well, you've done 50%. You then transfer your assets into your revocable trust. That's the way to avoid probate. So the last sort of basic document that we deal with, and it's not really always something we prepare, but it's definitely worth mentioning, are your beneficiary designations for retirement and life insurance. And they often, they get pushed to the second half too. So when I say you're 50% done, you really are. We want to make sure your beneficiary designations are doing what you want them to do. So easy example. I create a trust or 3 trusts for my children when I die. Let's say my wife has predeceased me. And I've got a $3 million life insurance policy. And the life insurance policy beneficiary designation says give it to my kids equally. The trusts I've created for them say hold the money in trust until they're 50 with these kinds of distributions, with my brother as the trustee, overseeing the money and making decisions, helping the kids with their finances. Well, if the $3 million life insurance policy, if I don't change the beneficiary designation, it's not going into those trusts. And so that's something that you always want to pay attention to. Now, I may not want that, right? I might have the life insurance going to the trust for my kids, but what if I have a 401k and I just say leave that to my wife? Well, that's fine. Or if I have an IRA, and there might be reasons I want that to go directly to my children, not into the trusts for them. So I'm not suggesting that the beneficiary designations have to mimic the estate plan, but pay attention to them. And my personal awakening was when I left Mason Valentine Troutman Sanders to join the firm Armstrong, Bristow, Farley, and Schwarzschild. I rolled my 401k over, and my partner said, make sure you do your beneficiary designations. And I said, well, I'm sure they're fine. And I looked at it, and it had my wife as the primary beneficiary, and nobody named as the contingent beneficiary. Because I was busy I'm starting a new job, filling out forms. That's a pain. I don't know all my kids' middle names anymore. You know, there's too much work here. And so even if you think they're okay, when you review your estate plan, I always encourage people to review the beneficiary designations as well. All right, any questions? How am I doing on time? It can authorize your agent to issue or sign a DNR order, but it does not in itself act as a DNR order. You go to your doctor. Yeah, they've got a pre-printed form. If you ever go to the hospital, they're bound to offer you one. And insurance covers that too. I mean, that's one of the forms they always give you.
Use the mic, please.
Oh, sorry.
I'm sorry to be so.
Thank you.
Now I forgot the question. Hold on. Dying intestate. Explain in a few words you can what happens then.
So dying intestate means you die without a will, I'm going to ignore the in as few words as possible comment. So if you die intestate, there's a statute in Virginia. I've been told it was written by Thomas Jefferson. I don't know if that's true. It's changed some over the years, but surprisingly not that much. And there's a list of heirs. And I think it's 8 or 9 categories. I have one that I'm actually working on right now where the guy died without a will, and he was not married, no children, no brothers, no sisters, parents deceased, and we hire an heir locator service, and now we call these people laughing heirs, because when you call them and say your second cousin twice removed Johnny died and you're a beneficiary, they start laughing. That's unusual, but I see about probably one of those a year, maybe it seems like. But that's kind of an unusual case. So if I die without a will, my wife gets everything. If I die without a will and I have children from a prior marriage, my wife gets 1/3 and my kids get 2/3. If I'm not married and I don't have kids, it goes to my parents. They're dead, it goes to my brothers and sisters. If one of them is dead, it goes to their kids. And we go down the line until we find somebody. That is very much going through the court. Yeah. And, one of the things that I haven't done the math on this last one, but sometimes people, you'd be surprised, but some people don't like paying lawyers. And so, and they're worried about my fees and my billable rate and this, that, and the other thing. And I said, well, I just had this case where this guy died without a will, and it cost $15,000 just to get his stuff to where it needed to go, because we had to hire an heir locator service. We got to figure all this stuff out, call all these people. And so it pales in comparison just to do it right up front. I think I saw a hand over here.
Go here.
Here you go.
And Gordon will go here, and then you.
Okay.
One question. Well, you started with your comment about taxes, so I'm going to go back to taxes, because when we say that, people kind of wince and go, oh my God, I don't want to be paying taxes. But estate tax, right now it's 26 million, going back to 12. What percentage of the population actually pays estate tax?
Very few.
Very few. Do you have a percentage, kind of like 2,
Less
3?
than 1%.
Yeah. Okay.
I'm looking at Jane because she's.
Yeah. Oh, Jane, I didn't see you.
Jane?
Yeah. Yeah. So, I mean, the term estate tax applies really to the very, very, very few people. I just wanted to get that point out.
Yeah, you're exactly right. I mean, my personal experience is it applies to a minority of our clients, and so your point is well made. When it does apply, it's really painful because it's 40%, and that's down from 55% when I started practicing. So yeah, that's a good point. Yes, ma'am.
Families are a big part of the challenges in estate planning, both by the person who's, the family member who's trying to pass on their good deeds, and the other side is the legal process. How much background do you have in family process, understanding the relationship systems and how they work, to know how to work with them in a highly emotional time? And if you have that background, it really does you have ways of calming down the system.
Yeah, I think that's a great question. I'm the youngest of 5 in an Irish Catholic family. So I know about crazy families. That's a fascinating question. A lot of times it depends on what my clients tell me, right? Because I'm only as good as the information they give me. And so, in those family dynamics, unfortunately, I have no statistics to back this up, but it feels like they come out when the matriarch or the patriarch has died. And the unscientific way of explaining that is everyone's on their best behavior until the matriarch or the patriarch is deceased, and then the knives come out. And we talked about contested guardianship cases being awful. That's an awful thing as well. And so, we don't personally deal with family counseling, but we do a lot of the work I do. I used to do a lot of fiduciary litigation. I don't do that anymore. I now call it dispute resolution, where I try to help people who are in a dispute find a way out that doesn't involve judges and juries and hundreds of $1,000s of legal fees. But some of those issues are really, really long-standing and deeply held. Not to tell war stories all day, but it was many years ago, I had this case where the brother and sister were just at each other's throats. They'd all behaved perfectly until mom died. And it was silly. Not a ton of money involved. And we got them to a point where they were going to have a settlement. I represented sister. And they wanted to talk about who was going to insert the semicolon in the next paragraph. They were fighting about everything. And we finally have a deal. And I call her up. I'm like, great news. We have a deal. We're exactly where you wanted to be. She said, as soon as I get a written apology from my brother, we'll be done. I said, what for? When I was 8, he threw a football in my bedroom and broke all my Himmel figurines. And I said, no, we're not doing that. And so I talked her off the ledge, but that speaks to, and she was in her 50s, right? This was something that obviously was bothering her. And so there really are, this might be a cop-out, but there are limits to what, we can do in situations like that. I don't know if that helps or answers your question, but.
I was just going to say that I have resources available that are really good people who know about family process and legal configurations.
Oh, good.
One is a lawyer in Rockville who's had an extensive history in family process and family systems. I'm talking about the emotional process.
Yeah.
And another one is a family consultant for family businesses. And those are another biggie to tackle.
Yeah.
When a major person dies. And I also have my older son who died a year ago, or a little over a year ago, with no will. And this is a thought for parents. This is a young man, 37, in his first full-time job with benefits. And he had not had time to consider a will. And I'm not sure I would have thought about it myself at the time, because he was not married, no children. He didn't think beyond that.
Right.
And that is a time that he needs to have a will, because he has benefits from his new professional job.
That's right.
So it's certainly something to think about for your children once they're out of college and into jobs. They get benefits that they don't see in their lifetime. You see it later.
Right. Right. Whenever an expert asks me a question, I get nervous.
Well, an expert in what I was taught is an unknown drip under pressure. So I'm not an expert. Maybe I am an expert. No, my thought is talk about holographic wills. At least a person can write his own will and get out of the doghouse as far as that aspect of not having a will is concerned.
Yes, so a holographic will is a will that's written in your own handwriting entirely. It's not a typed will with a bunch of written notes in the margin. It's in your own handwriting. It's dated and it's signed. And that's a valid will. Does it need witnesses? It does not need witnesses or a notary. And so you're right. That's better than nothing sometimes. Yes. Yes. Would it be self-serving of me to say we discourage that? You should. Right. Yeah. But in all seriousness, I do say that's sometimes better than nothing, because I've seen holographic wills that are totally inconsistent within their own provisions. A holographic codicil is inconsistent with the will it's trying to amend. It's ambiguous, it's unclear, and so it's sort of like Chief Justice Berger. You can do your own, but make sure it's understandable and clear.
Hold on, Evan. Hold on. It's all the people listening online who can't hear you, unless you. So.
But I have a tip for anyone. If anyone ever asks you to be an executor of their estate, all right, you want to carefully consider that. You want to sit down with that person and go through all of the necessary records and everything, and make sure that they have all that together. Because if you don't, you will spend many frustrating hours, and I know this from personal experience, trying to figure out where the records are, what do I need to get, and all that. And it'll be 3 times as difficult as if you know ahead of time what that person wants. So that's my tip on wills.
And I would add to that one of the best things we see, one of the best things you can do for your family is have a detailed list of what your assets are, where they are, account numbers, passwords, accountants, financial advisors, your lawyer, right? Like, have all that information. One of the most frustrating and time-consuming, which in my world equates to expensive, things about administering an estate is when the surviving spouse or children come in and they don't really know what the assets are or where they are. And what we do often is say, well, just wait for the mail. Hopefully they're getting paper statements. A lot of people don't get paper statements now. So let's look at the old tax returns. Maybe there was some income reported, and now it's a scavenger hunt. And it's very frustrating, time-consuming, and expensive. So that's not a legal document, but it's a huge thing you can do, is just make sure, and you don't even have to keep it updated, right? I mean, if you get people 95% of the way there in terms of what you have and where it is, that's a big deal.
I have a question. If you're leaving money to your children who are married, is it automatically to both your child and their spouse, or can you just do to your child?
It's whatever you want.
Okay.
There's nothing automatic. If I leave assets to my son, then in my will, then his wife is not a beneficiary. Now,
Okay.
what he may choose to do with it is put it in a joint account or who knows what, right?
Does that include things in the house? I don't know.
Yeah, it could.
Okay, thanks.
Yeah. So one of the things that I had talk a little bit about trusts, and your question brings it up. I mean, I get that question a fair amount. And there's a fine line between what what we're told in law school is they call it dead hand control, right? Coming from the grave and controlling your money and exactly how your kids can spend it or not spend it or what gets, what happens to it. That's one extreme versus I'm just going to leave everything outright to my kids and let them figure it out. And it depends on who your kids are and what kind of situation they're in. And it might also depend on their tax situation because there can be tax benefits to leaving the money in a trust for your kids. But one of the things that, and I always have to be careful, I feel like when I'm talking to my clients, they say, well, I want to leave everything equally to the kids. I say, okay, outright or in trust. Well, why would we do a trust? And now I feel like I'm advocating for it, which I'm not because it's not my decision. But the benefits of leaving assets in a trust are, one of them is that when the assets, as long as they're in there, they're not subject to the beneficiary's creditors. And the biggest creditor most of us all heard of are former spouses, right? So it's protected from divorce and creditors. And what a lot of my clients do who have otherwise perfectly normal, functional, happy families is they might say, well, I'm going to create a trust for my daughter or my son, and it's going to last for their lifetime. So I get this creditor protection, and I'm going to make them their own trustee. And it's a little of the rooster watching the hen house. But if I'm comfortable leaving my assets outright to my daughter, then I should also be comfortable leaving them in a trust for her that she is her own trustee. So she doesn't have to go to a stranger or a third party or a big bank and say, may I please have some more, right? But the hot water heater's broken or I can't make my car payment. Please give me a distribution. She is her own trustee. And again, there's no one size that fits all, but talking about leaving assets to one child and can they end up in the hands of that child's spouse? Well, one way, if that is a concern, one very easy way to fix that is leave them in trust.
Question here.
You might also mention that there's expense involved with trusts. You have to do a tax return and an annual accounting, correct?
Well, not necessarily an annual accounting. We do them all the time. I think they're a great idea. You do the real expense if I create a trust for my child and my child is his or her own trustee, the real expense, to my way of thinking, is the preparing that tax return, which, I don't know, a couple $100, $1,000, but it's not nothing, but it's probably not cost prohibitive. Where it really makes a difference is if I hire a third-party trustee, and now I'm paying trustee commissions. But you don't have to file an accounting with the Commissioner of Accounts if you've done it right. That's a short way of saying that. So yeah, there are, to me, I think that really is, I always talk about the pros and cons of trusts, and the added cost is really the con. If my child's their own trustee. Any other questions? How am I doing, Bill? 4 minutes? Someone come up with a question, yes.
Oh, hold on, John. Sorry. I know you love this microphone so much, but...
You mentioned when you started, just in passing, generation skipping provisions. Would you talk about that a little bit and the benefits?
I can't do that in 4 minutes. Generation skipping is, it's a bit of a misnomer in some respects. So if my mother leaves, let's make it fun, and she went to her great reward 5 years ago, so this will not happen. This is purely hypothetical. She leaves $1 million to my son. That's a generation skip, because she didn't give it to me. She gave it to her grandchild. And there's a tax on generation skips. But we also have an exemption that happens to be $13 million. So my mother could leave $13 million to her grandson and not have that tax. The reason I think it's a misnomer is the most common generation skipping planning we do is my mother creates a trust for me and my descendants. And that trust lasts for my lifetime and their lifetimes. Doesn't have to be that way, but that's common. And I am a beneficiary of that trust. So it really isn't skipping me because I can be a beneficiary of that trust. I could also be a trustee of that trust. So when we talk about generation skipping, in that context, I think more of lifetime trusts.
But the advantage is not in the first donation, right, but down the line, second, third, fourth generations.
Well, it could be in all of that, right? So depending on the circumstances, let's assume a bunch of things. Let's say my mom I'm the only child, she's got $13 million of assets, she leaves them all to me in a trust. There's no estate tax on that because she had a $13 million exemption. Whatever that trust grows to, at my death, it is not subject to estate tax. And whatever it grows to at my children's death, it's not subject to estate tax or GST tax.
That's the point, right?
Yeah. Yeah. Okay, on that happy spiritual note, I think we're done.